Ladies and gentlemen, hello. My name is Paul Cheng, and I wanted to thank you for coming to my channel. I wanted to thank you for joining me. Today, we're going to be talking about and going through more of the information regarding hire to fire, both from the employer side and the employee side, so you know your rights and obligations in California. You know, I actually get paid for the following lecture I'm going to be giving. It's a lecture called Hire to Fire. And this is not only good for employers, but this is really good for employees because it's able to identify typical errors that I see from the hire to fire process. And I believe that if you go through it and you're able to learn what I'm teaching you, you're going to do a good job. You know, one of the things that I've always said is there are two things that people always ask me. Is it legal or illegal? Legal or illegal? And I always say that it doesn't fall really under legal or illegal because you're not going to have an attorney sit next to you every single day. So you're constantly going to be hearing throughout this lecture what are called best practices. And best practices many times isn't a legal or illegal issue. I would always say this, particularly to those that are employers. What would the most ideal employer do? What would the most ideal employer do in a specific situation? Now, if you don't know what the law is, believe it or not, if you always say to yourself, what would the most ideal employer do? You will find that 99% of your decisions are going to be legal. That's what I consider to be best practices. And when I hear the word best practices, nobody ever says what they mean. And I believe what they mean is what would the ideal employer do? So let's start. Just to let you know, as I've always said, although I am giving a lot of legal commentary, you and I do not have an attorney-client relationship. If you're interested in retaining our firm, great, come on in, give us a call. 626-356-8880. 626-356-8880, located in Pasadena. Love to be able to meet you. Also do a lot of Zoom calls. So why do I recommend learning about labor law? Now, 90% of the population is going to be an employer or an employee. And it's so critical to learn labor law, particularly if you come from another country and you come to America. Although general concepts are the same, but specifically, California law is going to be very different from many other parts of the world and even in many parts of the United States. California is such a unique place to do business. We are the best state in the world. We got so many opportunities, but we also have the most lawsuits in the entire nation. We have more lawsuits in the state of California than all of the 50 states combined. I know it sounds really crazy. I will sit in a courthouse and the filings that come in are usually 10 to 15 an hour. So you can imagine how many lawsuits we have in the state of California. It's absolutely critical that you learn labor law because the majority of the lawsuits that are being filed are labor law related. Now, today what we're going to be talking about really isn't going to be related to workers' compensation. So we're not going to be speaking about workers' compensation, but just very quickly, in California, if you hire an employee, you need to have workers' compensation. If you do not have workers' compensation and an employee gets injured, they can be able to sue you on workers' compensation and you automatically lose, or they can file a civil lawsuit against you. One of the things I'm going to be doing is I'm also going to be deviating and talking about different lawsuits that I see. Don't forget, if you are hiring a nanny in California, you are hiring a nanny in California or a caretaker, make sure you tell your insurance company because many of the insurance that people buy do not encompass nannies and caretakers at your house. And if you get sued, you're going to end up having personal liability. I recently had a lawsuit where a nanny got injured and we ended up paying a lot of money for a broken hip. One of the reasons why you want to learn about labor law in California is because there's something called the attorney fees provision. And what that means is if an employee sues you and they win, you need to pay for the plaintiff's attorney fees and costs. I was actually in a lawsuit, the case got transferred over to me, and it was only about $70,000 in damages. And it's a lot of money, don't get me wrong. But the other side asked for $700,000 in attorney fees. I told the client at that time, the case got transferred over to me, I didn't lose a trial. I said, oh, don't worry about it. $70,000, $700,000 of attorney fees? Don't even worry. The judge dropped it down to about $450,000. And I told the judge, Your Honor, it's not reasonable. And the judge says, if you think that's unreasonable, you can take me up on appeal and see if that was reasonable or not. So it lets you know that in California, if the employee wins, they get their attorney fees. That's really the biggest hammer in the state of California. And that is if you lose and you're on defense side, you're an employer, you owe the attorney fees and costs, and it could be substantial. It could be massive. It could be very, very heart-wrenching, particularly for cases that aren't that big. So again, that's another reason why you need to learn labor law, to try to avoid the labor law lawsuits that are out there. Another reason why I think it's very critical to learn labor law is because it really hits small business that much harder. You know, if you're a big company, right? You're a Walmart, you're a Starbucks, the litigation is just part of running your business. Well, small business, which I want to say if you have a small business, keep it up. America's best days are coming because of small business. Don't get discouraged. But a lawsuit, when it hits a small business, it hits it hard, right? $300,000 or $450,000, well, that's a drop in the bucket, right? For a big entity, Walmart or Starbucks or things like that. I mean, they care, but it's not going to close them. But a $400,000 lawsuit, $500,000, $1 million lawsuit, that collapses most small businesses. So again, that's another reason why you need to learn labor law. Earlier, I talked about in California, if you hire an employee, that you need to buy workers' compensation. Just to let you know, there's a presumption of employment in California. So there are really two big types of workers in California. You're going to have your independent contractors, 1099, and you're going to have regular employees that are split up in kind of different tier levels that I'll be able to explain. But in California, there's a presumption of employment, meaning that all things being equal, you don't really know. Under Labor Code 3357, it's going to be a presumption of employment, meaning they're an employee, not an independent contractor. What I need you to look up really quick is something called ABC. I know it sounds really simple, right? But that's the reason why people respect doctors so much more. They have these really long, difficult names. But what attorneys need to do is they need to simplify concepts. And what the California Supreme Court and subsequent courts have said is that there's something called the ABC test. And if you don't comply with ABC test, it's presumed that any of your workers, all of your workers, are employees. And really the ABC test is really one of control, but the one that I find is the most difficult in the ABC test is it basically says that if this worker is doing the same business as you, it's not going to be an independent contractor. So let me just give you an example. Let's say I hired somebody at my law firm and they come in and they install a refrigerator. They're an independent contractor. Why? Because my law firm is a law firm. I don't do the refrigeration business. But let's say that I am in the refrigeration business, right? I install fridges, basically different material at offices, and I hire somebody to install a fridge for me, for my customer. They are not an independent contractor because I am in the refrigeration business. I install refrigerators, and I've hired a worker to install a refrigerator for my client and I am in the refrigeration business. That's really the most difficult part of the ABC test, is if you hire somebody that does the same business as you, it's presumably an employee. Now, there are some exceptions behind that, but we're not going to go too deep into the ABC test, but I want you to know the ABC test, the big one that nobody seems to be able to get around, is that if they do the same business as you do, the worker is not an independent contractor. Well, people say to me, well, geez, I signed a contract with this worker as an independent contractor. They agreed that they're an independent contractor. I agree that they're an independent contractor. They must be an independent contractor. In the past, that would have worked. It doesn't work now. So even if you have a contract that says the worker is an independent contractor, if the worker decides to sue you, you're going to lose that case. So it's very important you understand that the independent contractor status is not one of intent, but it's actually one of law where they have to comply. A lot of people lose independent contractor cases. Just to let you know, at our law firm, right, we have both a split of both employer side and employee side. There's one thing that employers do not do when they hire an independent contractor. They do not fill out the form DE 542. DE Delta Echo 542. DE 542 says if you hire an independent contractor, you pay them over $600, you need to file a form with the state of California. Now, if you go to your accountant and you say, hey, what's a DE 542? Did you fill it out? You know what the accountant's gonna say to you? I don't know what a DE 542 is. And the reason why they don't know it is it's not a federal form like the IRS 1099. It's actually a form with the state of California. So many times when we sue employers and they claim, oh, that person's an independent contractor, we didn't need to give them meal break, rest breaks, overtime. The problem is that they've never filled out the DE 542, and the form actually says you have to fill it out if you hire an independent contractor. Don't forget to fill out your DE 542s if you're an employer and you're hiring an independent contractor. Thanks for joining me. We've been talking about a lot of issues related to employer, employee, and labor law. Next time, we're going to go further on those issues to be able to discuss more detailed information and what I call hire to fire. Thank you.